welcome aboard. So what happened in court today is that the Supreme Court adjourned the matter until today to give a ruling. And they did give a ruling today. The ruling was about this. At the close of the case of the petitioners, that is President Mahama and his lawyers, the respondents were expected to now open their or continue with their defense. And then the lawyer for Electoral Commission, Justice Nuvo, announced that he is unable to do so, and he doesn't think that it's important to do so because, as far as he put it, the petitioners, Mr. Tsikata and co., had not made any case that requires them to respond. And we had discussed and analyzed this on this program last Thursday. So he said that he was not going to call his witness, Jean Mensa, and that created a bit of uproar and concern and conversations all around social media and all around the country and those who are interested in the politics of the Supreme Court. So the conversation all over the weekend was, do they have the rights to do that? Do they have the right not to do that? When the Supreme Court had the application for the first time, they adjourned and they decided to come back today to give a ruling on the matter. Today being Thursday, they adjourned on Tuesday to come Thursday to give a ruling on the matter. So all of Wednesday, the discussions continued. Lawyers of different fraternities gave their different opinions about the matter. There were those lawyers who felt that this is a straightforward matter. Jean Mensa cannot be compelled to give evidence in the case. She doesn't want to give evidence. If she elects not to give evidence, actually against her. Mr. Tsikata made a forceful argument and said that the matter public interest. Jean Mensa has already begun the process of giving evidence by filing a witness statement, and therefore it is too late for her to backtrack and to say that I don't want to give evidence. So he urged upon the court to rule in a way that will allow them to cross-examine Jean Mensa. Now today, the court gave its ruling. So let's go straight and have a look at it. So we have isolated the ruling in different parts for you tonight so that you can, so it's not all of the ruling, but it's those parts that based on our editorial decision, we believe that when we share with you, you will completely understand the matter, even if you have no acquaintance with the law whatsoever. And then you also understand if you want to interpret it from the public policy perspective, if you want to interpret it from the political perspective, even if you want to interpret it from gender perspective, it's entirely up to you how you do it. What we are going to do now is just to bring the matter to you in the most simple terms that we can. So we have explained to you already what was the matter before the court. The court was to make a decision whether, having closed the case of whether the petitioners, President Mahama, having ended his case. Ended his case means that he has called up his witnesses. They've told the court why he believes that the election was invalid. And he called witnesses Jean Mensah, the General Secretary of the party, Rojo Metil-Nunu and Dr. Pesa White, who were both at the Electoral Commission strong room on the day of the declaration and the day of the collating of the final results from all the regions at the Electoral Commission. So all of them have finished speaking. When they speak, they are cross-examined by the other lawyers. So you heard Akoto Ampao and Johnson Asiri Nkatia, which we all enjoyed. You heard Rojo Metil-Nunu, an Electoral Commission lawyer. We all enjoyed it to the point where we now learned that it's important for tea to go with biscuits to be completed. That tea without biscuits is incomplete. That's just on the lighter side. So, but we had all of these things in court. We all enjoyed it and enjoyed the extent of democracy in our country. The court was expected to rule on this matter. They have now delivered the ruling. Let's go and understand what the court said. Point number one, the first part that we isolated for you. This is Justice Eni Yeboah speaking. He said, now at the close of John Mahame's case, lawyer for Electoral Commission announced to the court that the Electoral Commission does not intend to adduce any evidence in the case and therefore wanted its case closed. Counsel for Nana Akufo-Addo associated himself with this position taken by the Electoral Commission and reiterated that Nana Akufo-Addo will also close his case because he was not adducing any evidence. I think we get that clearly. So what I'm trying to do is to substitute first respondent for Electoral Commission because that is what it is. Substitute second respondent for Nana Akufo-Addo because that is what it is. And counsel just means a lawyer for each of the parties. So let's move on. Okay. Slide number 2. This is Justice Eni Yeboah talking. He says, both counsels submitted that having regard to the evidence led by John Mahama through his witnesses, they, Electoral Commission and Nana Akufo-Addo, do not deem it necessary to adduce any evidence in the matter. Now, this is another important point. So the courts, the lawyers for Electoral Commission and Akufo-Addo are saying that really, after John Mahama spoke in respect of the election petition, in respect of challenging the validity of the election, he didn't quite say anything. He didn't say anything substantial. He didn't say anything that requires us to answer the question. By what he said, he himself has lost his case already. So we don't need to add anything. This must be the contextual understanding of what we just read. The lawyers for Electoral Commission and Nana Akufo-Addo say that we have heard John Mahama. There's nothing he's saying. He's not saying anything substantial. All he's saying is not sufficient to get this court to change any decision. So we don't want to say anything. That's what it is. Okay, next one. This is Justice Eni Eboa talking in the ruling delivered today. He says, and the lawyer for John Mahama opposed the position taken by Nana Akufo-Addo and the Electoral Commission and argued that Nana Akufo-Addo and the Electoral Commission, especially the Electoral Commission, cannot refuse to give evidence in this petition. That's interesting. So after Nana Akufo-Addo and Jean Mensa said that they are not interested in giving evidence, Mr. Tsikata is telling the court that no, they can't do that. They cannot do that. They will have to come and give evidence, especially the Electoral Commission. She will have to come and give evidence. This is Eni Eboa reiterating what had happened in court before he gives the court's ruling on the matter. Okay, so it goes on. Lawyer for John Mahama argued further that the Electoral Commission in particular, besides filing an answer to the petition, has also specifically deposed to an affidavit in opposition to an application to serve interlocutors in which the chairperson of the Electoral Commission indicated her availability for cross-examination. Let's get that again. Lawyer for John Mahama, that's Mr. Tsikata, argued further that the Electoral Commission in particular, besides filing an answer to the petition, has also specifically deposed to an affidavit in opposition to an application to serve interlocutors in which the chairperson indicated availability for cross-examination. So that's the point that Mr. Tsikata is making. What he's saying is that, well, wait a minute. The people who are saying that they do not need to give evidence, those people, Jean Mensa and Nana Akufo-Addo, they say they will not give evidence, and therefore they will not call their witnesses. So Tsikata here was telling the court, and this is being reiterated by his Lordship, the Chief Justice. The Lord Chief Justice is telling us this in the judgment that came today. He's saying that Jean Mensa especially, when she was filing an affidavit in opposition to the petitioner's request that she should bring some documents for us to inspect, when she filed that affidavit, in that particular affidavit, she actually said that she will not bring those documents, or the court need not ask her to bring those documents, because she will be available for cross-examination, and during cross-examination, those documents can be looked at. This is what Mr. Tsikata is reported to have said, according to the ruling that the Lord Chief Justice read today. That, don't forget about her. Don't worry about her. She said that she will be available for cross-examination. How can she now then come and say that she will not be available? The court should not allow it. Mr. Tsikata was urging on the court should not allow it. Okay, let's move on. This is still the Chief Justice talking in the ruling. He says, finally, it was contended by the lawyer for John Mahama that the Electoral Commission's chairperson performs a very important constitutional function, and as such must be made to adduce evidence in this petition to account for his stewardship, her stewardship it should be, to the people of Ghana. Now that's Mr. Tsikata is saying that, urging the court that please let Jean Mensa come and adduce evidence because she performs a very important function. She cannot say in these circumstances that she will not adduce evidence. So let's move on. We'll hear more about what the court says. Okay. It is also an undisputed fact that a defendant in a case can elect whether or not to adduce evidence at the close of the plaintiff's case when such a defendant is called upon by the court to open his or her defense. So, and you have to understand that this is not following a chronological order because we took out certain matters that are purely legal. For instance, in this ruling, Justice Eni Eboa relies on all the civil procedure rules, which you will find Order 39 rule this, Order 38 rule that, Order 75 rule that. We didn't want to ornament this presentation with all of that, and that perhaps will confuse some of our viewers. So we didn't want to do that. So we have taken out all of those reference to the civil procedure rules and just left what will make people completely follow what we are doing. We hope that we got it right, but that's what we did. So we have not changed anything, but we are not presenting it in the same chronological order that the Lord Chief Justice presented it today. So here, Chief Justice says, it's an undisputed fact. Now, before he said this, he had referred to the civil procedure rules, and he had given the basis on why he was saying that. You remember also that we told you at the beginning, when we were analyzing the history of all of these judges, that the Lord Chief Justice is given to procedure. He shows tremendous fidelity to the procedure of the law. And so we would expect that in coming to the election petition, he will be looking at it from a very strong procedural spectacles. And we are not surprised that he comes up here in delivering this particular ruling. He is relying heavily on the procedure. So he's saying that according to the procedure, it is an undisputed fact that the defendant in a case can elect whether or not to adduce evidence at the close of the plaintiff's case when such a defendant is called upon by the courts to open his defense. So what he's saying is that when the one who takes the matter to the court, when that person has finished his matter, it is up to the person against whom the case had been made to decide whether they want to say something or not. Indeed, if A sues B or if Paul sues Peter, Peter can decide not to appear in the court at all. He can decide that he doesn't care. There are consequences, legal consequences, even custodial consequences for such a behavior. Custodial means that you could be imprisoned for such a behavior. But you can really decide not to appear. So when you appear, you can decide to say nothing. All of what happens in the court, your conduct, your behavior, the things you say, the things you don't say, the things you refuse to say, will then be used in the judgment. So it is at your own peril to decide what you want to do. That's what the court here is saying, that a defendant can decide that he doesn't want to appear in the court. He can decide he doesn't want to. That's why they use the word elect. That's what the word that is used in the procedural rules. You can elect not to say anything. Okay, let's move on. So it says, this is the court speaking in quite strong terms. We are of the considered opinion that it will be wrong in law to say that a party is deemed to have elected to adduce evidence as soon as that party files and serves evidence in compliance with a court order. To hold same will mean that once a party files and serves a witness statement, that party mandatorily has to mount the witness box and adduce evidence at the trial. This position is not born out of the rules. So we believe that everything turned on this part of the ruling. Everything turned on this part of the ruling because the matter is simple. One side says that Jean Mensa must come into the witness box, and Jean Mensa says that I can elect not to defend myself at this stage. The other part says that no, you cannot elect not to defend yourself because that decision, that position, you can't take that position because you have lost that opportunity. In Mr. Tsikata's words, he says that the ship has already sailed. He said that ship has sailed, that you have lost the opportunity at this stage to take a decision whether you want to defend yourself or not. Why? Because you have already filed processes. And in some of those processes that you filed, you said that you were available for cross-examination. So you cannot come at this stage at the close of the case and say that, well, I don't want to be part of the case. Now, this is what their lordships are saying. Very important. Let's look at it again. Their lordship said that we are of the considered opinion. That is to say, we firmly believe this matter, that it will be wrong in law to say that a party is deemed to have elected to adduce evidence as soon as that party files and serves evidence in compliance with the court. Okay, so let's try and understand it. So Mr. Tsikata said that Electoral Commission, you have filed a witness statement. You have. Electoral Commission, you have filed an affidavit in opposition. You have. In filing those affidavits in opposition and in the witness statement, you made statements, sometimes directly saying that you'll be available for cross-examination, or made statements to the extent or to the point that you have provided evidence. The court is saying you cannot use that against the party. You can't say because they have done that, they have opened their defense. Because those things that they did was in keeping with, as they put it, compliance with the order of the court. the court ordered that people should file their witness statements. So if I file my witness statements in compliance with the court order, you cannot use that against me to say that I have elected to give defense. No. The only part where we decide whether I want to give, you can't say I've elected to give evidence, sorry. The only part where we decide whether we are giving evidence or not is when the plaintiff has closed his case and it is my turn to open my case and I said, sorry, I'm not interested. He has not made any point. I don't need it. All of that will go against me in the ruling, or it will go for me in the ruling one way or the other, but I can elect at that stage. So the critical point is in the journey of the trial, at which point can the defendant elect that I don't want to continue? The court seems to be saying that the defendant can elect only at the close of the plaintiff's case, that everything the defendant does before then, in terms of filing documents and writing witness statements and all of that, is done because of the compliance of a court order. When the court orders, they do it. When they've done it, you cannot use that to interpret the fact that at the middle part of the case, they will surely open their defense, or they have already opened their defense. So when you get to the junction where they have to make a decision, you say they have already made the decision. The court is saying, no, you can't say that. They have to get to the junction, they have to get to the bridge, and they have to make a decision whether they want to continue or not, because they are the people who have been sued. You're the party who sued. You make your case. You present your witness statement. The court orders them. Also, you also present your witness statement. Open your defense, however you want to call it. The court says, at that stage, it's compliance with the court order. You can't say that when they opened their defense, they said that I will be available for cross-examination. So, automatically, when you have closed your case and they evaluate what you have done, and they take a decision that based on what you have done, they don't want to continue, then you say, no, they have already crossed that place. They get to the junction, they get to the bridge, they tell the court what they want to do. The court believes that is entirely legitimate. In fact, the wording of this is very, very strong. They say that we are of the considered opinion that it will be wrong in law to say that a party is deemed to have elected to adduce evidence as soon as that party files and serves evidence in compliance with the court order. The court says to hold this will mean that one party files and serves a witness statement, that party must mandatorily. Now the question then is asked, in this election petition, if this were the case, some lawyers ask, if the promptings of the petitioner's lawyers, Mr. Tsikata, if what Mr. Tsikata was urging on the court is anything to go by, then having filed the petition, shall we say that John Dramani Mahama must mandatorily mount the witness box and give evidence? The answer is no, because John Dramani Mahama has filed a petition. He can elect to do this or that. He filed a petition in compliance with the rules of the court. The rules of the court says in filing an election petition, you file an election petition to the court and you sign it. It doesn't mean that you have to give evidence. You can give evidence if you want, but it doesn't mean you have to give evidence. This is what the court is saying. Okay. Let's move on. It says, such a witness cannot be compelled by the court to appear for cross-examination. He, the witness, suffers the penalty of the evidence being expunged from the record. This is exactly the position of the respondents. This is exactly the position the respondents have taken in this petition, where both respondents have decided not to adduce evidence, even though they have filed and served witness statements. Let's get that again. It says such a witness cannot be compelled. That is a witness who says, I don't want to go on. They cannot be compelled to appear before the court for cross-examination. He, the witness, in this case, Jean Mensa, Nana Akufo-Addo, suffers the penalty of the evidence being expunged from the record. This is exactly the position that the respondents have taken in this petition, where both respondents, Nana Akufo-Addo and Jean Mensah, have decided that they will not adduce evidence even though they have filed and served witness statements. Okay, let's come and understand this further. It's quite interesting. You see, the law can be very interesting and it can be confusing, but that is the law. That's the law that we've given unto ourselves. That's what the Constitution does. That's what democracy does. It gives us the law and allows the courts to be the final interpreter of the law. Okay, so what are they saying here? They are saying that when a witness says, I will not give evidence, when he says that, you cannot compel him to give evidence. You can't. You shouldn't. You can't do that. The court cannot do that, to compel him to give evidence. What happens, however, is that whatever evidence that witness may have given in a witness statement, it will be expunged from the record. So when the judges sit down to write the ruling, the final ruling, whatever you said will not, in the witness statement that you did not give evidence upon, that will not be considered. So Jean Mensa said, for instance, in her witness statement that I read the results on the 9th and I made a mistake, and Teshiman South I made a mistake with reference to something called total valid votes cast, and I didn't distinguish between total votes cast and total valid votes cast. That's what Jean Mensa said in her witness statement, and that was an error, which I corrected the next day. I have the press release of it. All of that, what Jean Mensa said, will be expunged from the record. So when Justice Nyashi Kote of the Supreme Court, empaneled member, sits down to write, if he's writing his own ruling, sits down to write the ruling, he doesn't know what Jean Mensa said. It's not part of the record. It has nothing to do with the record. He knows what Mr. Tsikata said. He knows what Mr. Tsikata's witnesses were asked by Akoto Ampao. He knows what Mr. Tsikata asked his witnesses. He knows what President Mahama said, but he doesn't know what Jean Mensa said. It's not part of the record. He doesn't know what Peter McMenu said. It's not part of the record. That's what their lordships are saying here, that such a witness will suffer that penalty. He will suffer the penalty of not knowing of his matter being removed from the record. I don't know whether that is clear, but that's what they are saying. That there's a consequence for this. There's a consequence for deciding that you don't want to proceed by giving evidence. There's a consequence for it. They are assuring Mr. Tsikata that there is consequence for that. The consequence for that is that whatever they have already said, upon which they do not want to give evidence nor proceed, will be expunged from the record. That's the consequence. So now, as the Supreme Court gets ready to receive the addresses and to give the ruling, when they are giving the ruling, they will not make any reference to anything Jean Mensa said. It's expunged from the record. That's what she suffers by deciding that she will not give evidence. Okay. By the ruling read and the respective cases of Nana Akufo-Addo, of Jean Mensa and Nana Akufo-Addo are deemed to be close. Okay. This court hereby orders that the parties herein should simultaneously file their respective closing addresses submissions on or before Wednesday, the 17th of February 2021. The petition is hereby adjourned until the 18th of February 2021 for the lawyers in this petition to highlight on the written addresses and submissions so filed for the petition to be adjourned for judgment. Okay, so we are coming to the conclusion of the petition. So the Lord Chief Justice says that, okay, the court hereby orders, once again a court order, the court hereby orders that the parties herein should simultaneously file their respective closing addresses and submissions on or before Wednesday, the 17th of February, that's next week, Wednesday. The petition is hereby adjourned to the 18th of February. They go to court and the lawyers will highlight a few things they want to highlight in the address, this and that, dot some I's, cross some T's, remove some sentence, change it, all that. All that will be done. The court will then be adjourned for the final ruling. That's it. That's the end of the story. But is that the end of the story? No. Mr. Tsikata, we'll have his photograph here in a minute. Mr. Tsikata, before the close of day, has filed something else. Yes, he has. He and the NDC lawyers had indicated that they were going to file something else. So what they have filed, yeah, there you have it. That's Mr. TSATSU Tsikata. Oh, they're going to give you a shot. Okay, yeah, you can see it now. That's Mr. TSATSU Tsikata, a senior lawyer, very distinguished practitioner. A strong man. You can see that he's always on his feet. At the age of 70, he never gets tired. Now, he's filed another matter before the court. He's filing that he wants to reopen his case. He's making an application to the court. That's okay, I've heard your ruling. You agree with the lawyers of the respondents that Jean Mensa cannot be compelled to come into the witness box. Fair enough. Let me reopen my case. So the court is going to hear that application, I believe sometime next week, before the 17th. I believe so, I don't know. Now, the court is going to hear his application. He's going to argue, and he argues forcefully. He's going to argue before the court that allow me to open my case. The court is going to decide whether he should be allowed to open his case or that the court will stay with my brother. Your case is closed. Is that what they're going to say, or they're going to allow him to open his case? So that's what we are waiting for. That's the latest dimension to the election petition. Mr. Tsikata closed his case. He was hoping for a cross-examination of Jean Mensa. Jean Mensa says, I'm not coming into the witness box. An application is made in that regard. The Supreme Court, by a unanimous decision, agrees with that application, indicates that according to the rules of procedure, Jean Mensa cannot be compelled to come into the witness box. It may go against her. It's a decision she makes on her own, and she makes the decision at her own peril. Now, Mr. Tsikata said, okay, I hear you, court, I hear you. Now, if that is so, he says, let me open my case. And it's not automatic that he can open his case just like that. He has to file an application, which he has. The court is going to hear that. You can imagine that lawyers for the Electoral Commission and lawyers for Nana Akufo-Addo, led by Tony Akoto-Ampao, are going to be opposed to this application, and they are going to forcefully argue as well that the court should stick by where we are. Mr. Tsikata had closed his case. He himself said he's closed his case. We cannot open the case. Now, in opening the case, Mr. Tsikata is going to repeat some of the arguments about the necessity for Jean Mensa to be cross-examined. And he's make an argument that Jean Mensa should be subpoenaed before the court to answer some of the critical questions. Now, here is the legal catch. So, a party to a matter, we are told, cannot be subpoenaed. If you sue me in a matter, you cannot also subpoena me. Now, subpoena just means that, oh, sorry, we should have put it in the law dictionary up here. Subpoena just means that a party is compelled to appear before the court. But the person to be compelled in that subpoena usually is a non-party to the case. Usually, it's a non-party to the case. Now, so there are two strands of argument. Some lawyers think that Jean Mensa, in her personal capacity, is a party to the case because she's the chairperson of the first respondent and the returning officer for the presidential election. So she's party to the case. Some other lawyers believe that, no, she's not party to the case by herself, in her personal capacity, as they say in persona. She's not a party to the case. The first respondent is the Electoral Commission. That is why they say the first respondent's chairperson. That's why they say that. That the first respondent's chairperson is the returning officer for the presidential election. Some also say, no, wait a minute. The Constitution named her as the returning officer for the presidential election. So when an election petition says you sue the Electoral Commission, she's the one that you're suing. All of this is going to come up in the debate. It's going to be very interesting, and we're all learning from this, aren't we? I'm sure some of you are enjoying it thoroughly. So that's where we are now. We were thinking that if nothing happened, on 17th, addresses will be filed. On 18th, corrections will be made, and the court will adjourn for judgment. But alas, no, we are not there yet. Mr. Tsikata has an application now to reopen his case, and the court is going to hear that. There will be a determination made whether or not he can open his case. If he can open his case, he'll continue to open his case, and we'll hear about the subpoena and all that. If he cannot open his case, I don't know whether he's going to appeal for a review of that decision in case he loses. We don't know what will happen. But as far as the court is concerned, they are ready to sort of sum up and get over with this so that, as they say, we can get on with our lives.